Picture this. You are driving home, windows up, music on. You haven't broken a single law tonight, and then you see it. Blue and red lights flashing in your rearview mirror. Your stomach drops. Your hands grip the wheel a little tighter. You pull over, and you're already thinking, did I run a light? Did I speed? Was my registration expired? The officer steps out of the patrol car. He walks slowly toward your window. You roll it down, and instead of saying anything about your driving, instead of telling you why he pulled you over, he leans in close, takes a long, slow breath, and says 4 words that have the power to flip your entire night upside down. I smell marijuana. Just like that. No evidence, no drugs visible, no crime committed. Just those 4 words. And now suddenly, you're being told he has the right to tear apart everything inside your car. Your glove box, your center console, your trunk, everything. But here's what they don't teach you in school. Here's what most people standing on the side of that road don't know in that terrifying moment. That smell, that claim, may not be enough. And the way you respond in the next 60 seconds determines whether your rights survive that traffic stop or vanish completely. My name is Theodore Whitman. I'm a criminal defense attorney, and I have watched this exact scenario destroy innocent people's lives, not because they were guilty, but because they didn't know what to say. They panicked, they talked, they consented. And the moment they did that, it was over. So today, I am going to walk you through everything. The law behind the smell test, the tricks police use at traffic stops, what to say, what not to say, what happens to the other passengers in your car, which states have changed the rules entirely, and the exact words, memorize them, that protect your rights no matter what state you're in. Let's start with the foundation, because if you don't understand why this matters, you won't be motivated enough to actually use it when the pressure is on. The Fourth Amendment to the United States Constitution guarantees, and this is not just a suggestion, this is the supreme law of the land, that you have the right to be secure in your person, your house, your papers, and your effects against unreasonable searches and seizures. That means a police officer cannot legally dig through your car, your pockets, or your home without a real, legally sufficient reason. That reason has a name. It's called probable cause. Probable cause means the officer has enough concrete, articulable facts in front of him to make a reasonable person believe that a crime is actually being committed. Think of it like this. If you walk into your kitchen and there's smoke coming out of the oven, you have a reasonable basis to believe something is burning. You're not guessing. You have observable evidence pointing toward a specific conclusion. But there's another term you'll hear that operates at a much lower level, reasonable suspicion. This is the threshold cops need just to pull you over or briefly stop you. It's a lighter standard, less evidence required, just enough of a hunch backed by some observable facts to justify a temporary detention. Here's where the game begins. Police officers routinely pull people over on reasonable suspicion. Maybe you drifted slightly in your lane. Maybe your taillight has a small crack. Maybe you didn't fully complete a stop. And then they use that stop as a fishing expedition. Their real goal isn't the traffic violation. Their real goal is to build probable cause for something bigger. And the smell of marijuana has been their favorite fishing rod for decades. When a cop leans into your window and says, "I smell marijuana," that claim, in many states, has historically been treated as probable cause all by itself. No drugs visible, no admission from you, just his nose. And based on that alone, courts have allowed full vehicle searches. But the legal landscape is shifting, and if you don't know where your state stands, you are flying blind. So here are the 3 critical questions you need to ask yourself the moment a cop claims he smells marijuana in your car. Question 1. Is marijuana legal in your state? This is the single most important variable in this entire situation. If you are in a state where recreational marijuana is fully legal, Colorado, Illinois, California, and others, it becomes extremely difficult for police to justify a search based on smell alone. Because if the substance is legal, the smell of it doesn't automatically indicate a crime is taking place. Several courts in these states have already ruled that odor alone is not sufficient probable cause. The logic is simple. Legal smell does not equal illegal activity. But if you are in a state where marijuana remains fully criminalized, Texas is the clearest example. Courts are still allowing cops to use that claimed smell as the key to enter and search your vehicle. In Texas, possessing any usable amount of marijuana is still a misdemeanor subject to arrest. So in those states, when a cop says he smells it, he has just given himself a legal justification, at least in that moment, to go through everything. Know your state. It changes everything. Question 2. Is the officer claiming he smells burnt marijuana or fresh marijuana? You might think this doesn't matter. It matters enormously. Burnt marijuana odor, the smell left over after something has already been smoked, lingers. It clings to fabric. It gets into upholstery. It can stay in a car for days, even weeks. I have personally rented vehicles where the moment I opened the door, the smell hit me immediately. That car had been cleaned. The previous renter was long gone, but the odor remained. What does that mean legally? It means the burnt smell of marijuana is extremely difficult to tie specifically to present possession inside that vehicle. Someone could have smoked in the car days ago. You could have gotten a ride from someone who had just been smoking. You could have sat next to someone at a concert or a backyard gathering, and now that smell is on your jacket. Burnt odor does not prove current possession. Courts in multiple jurisdictions have recognized this weakness. Fresh marijuana is a different story. Fresh, unburned marijuana, the raw plant material, seeds, stems, the kind that's been recently handled, has a very distinct, pungent smell. Courts have been much more willing to accept that the odor of fresh marijuana tied directly to the inside of a vehicle indicates current possession. It's a harder case to shake. Here's the trap officers use. Smart officers know this distinction too. So instead of committing to exactly what they smelled, they'll try to get you to describe it for them. They'll say, "You smell that? What does that smell like to you?" And people, wanting to seem cooperative, wanting to appear innocent, will say, "Yeah, it kind of smells like weed." Congratulations, you just removed the burden from the officer entirely. You confirmed the smell. You handed him probable cause. Don't do that, ever. Question 3. Does probable cause for the driver automatically apply to everyone else in the car? This is one of the most misunderstood areas of police encounter law, and it's one where people get buried. In 1948, the United States Supreme Court decided a case called United States versus DeRee. The ruling was direct. Probable cause against a driver does not automatically transfer to the passengers in the same vehicle. The car is treated as a container. The driver has control of that container. Therefore, probable cause starts, and in many cases stays, with the driver. If an officer claims he smells marijuana and uses that to establish probable cause to search the car, that does not give him immediate, automatic legal authority to pull out every passenger, search every person, and arrest everyone inside. He needs separate, independently established probable cause for each individual passenger. This is critically important. And here's exactly how police work around it. They separate you. The moment they believe they have probable cause on the driver, one officer takes the driver aside and starts asking questions, looking for anything that implicates the passengers. Meanwhile, another officer approaches the passengers. He'll be friendly. He'll seem casual. He'll ask open-ended questions. He's hoping someone volunteers information, makes an admission, says something that gives him independent probable cause to act on the passengers. And here's the terrifying truth. If everyone in that car stays quiet, if every single person invokes their right to remain silent, there is no separate probable cause. The officer cannot legally pull passengers out of the vehicle and search them without it. But the moment one person talks, the moment one passenger says something that connects them to what's in the car, that silence is broken and everyone can be affected. So remember, if you are ever a passenger in a car that gets pulled over, you are not obligated to answer questions. You can politely say, "I'm choosing to exercise my right to remain silent," and then say nothing else. That is not suspicious behavior. That is the Constitution doing exactly what it was designed to do. So what exactly are officers looking for when they're trying to build that separate probable cause for passengers? Because they have a checklist, and if you know what's on that checklist, you can understand what they're doing in real time. They look for bloodshot or glassy eyes. They look for signs of impairment, slurred speech, lack of coordination, confusion. They look for what's sometimes called meth mouth, deteriorated teeth associated with long-term substance abuse. They look at fingertips, burnt lips, signs of active recent use. They are building a behavioral profile, and every observation they make gets noted on that report. But here is the key. They must articulate specific, observable facts. A hunch is not enough. He looked nervous is not enough. Courts have ruled on this repeatedly. The officer must be able to point to concrete, specific, articulable evidence connecting each individual passenger to the alleged crime. I once handled a case where a driver panicked the moment he saw flashing lights. Before the officer even reached the window, the driver grabbed his bag and shoved it under the passenger seat where his friend was sitting. The officer saw that movement clearly. That single furtive movement, combined with the claimed smell, gave the officer everything he needed to get both the driver and the passenger out of the vehicle and search everyone. That one moment of panic cost both of them dearly. Don't be that driver. Now let's talk about specific states, because the map of marijuana law in America right now is a patchwork, and where you live determines exactly how aggressive police can be with this tactic. Maryland. In 2020, courts ruled that the odor of marijuana alone is not sufficient to search a person, and as of 2023, that same standard now applies to vehicles. If you are in Maryland and an officer claims he smells marijuana and demands to search your car based only on that smell, you can say, and should say, "Officer, I'm aware that odor alone is not sufficient to establish probable cause for a search under Maryland law. I do not consent to a search of my vehicle." Colorado. Since 2019, even drug-sniffing dogs trained to alert on marijuana cannot have that alert used as standalone probable cause unless there is additional supporting evidence. The alert alone on marijuana specifically is not enough. Ohio. Since recreational legalization passed in 2023, smell alone is no longer sufficient for probable cause in Ohio either. Officers there are now pivoting. They're focusing on impairment indicators instead, looking for signs that you're actually impaired rather than simply claiming they smell something. Florida and Texas. These two states remain the most aggressive. Both still criminalize marijuana possession. Both still allow officers to use a claimed smell as probable cause. If you're in either of these states, you need to be even more vigilant and more disciplined about keeping your mouth shut and refusing consent. And here's something that matters in every single state. Hemp is now federally legal. Hemp and marijuana smell identical. The two substances are chemically indistinguishable by smell. An officer standing outside your window physically cannot tell the difference between the smell of legal hemp and illegal marijuana. That fact alone should tell you something about how much weight you should give to a claim of "I smell marijuana" from the side of a road. The best practice, regardless of your state, regardless of the situation, is always to refuse consent to search. Always. Never hand an officer your keys. Never say, "Go ahead." Never respond to, "You don't have anything to hide, right?" by opening your car or your home or your pockets. That phrase, "You don't have anything to hide," is a psychological manipulation technique. Innocent people assert their rights. That is not suspicious. That is American. Now let's talk about the loopholes, because even when the smell test doesn't hold up, police have other tools, and you need to know about them. Loophole number 1, the pretext stop. The Supreme Court case Wren versus United States settled this clearly. Officers can follow you, watch you, wait for you to commit a minor traffic infraction, a slightly wide turn, a momentary failure to signal, a brake light that's dim, and use that as the legal basis to pull you over, even if their actual goal is a drug investigation. The traffic violation is the pretext. The real investigation begins after you roll down your window. What does this mean for you? Keep your car legal. Signal every turn. Drive the speed limit. Don't give them the pretext. And if they pull you over and you sense this is bigger than a traffic violation, stay calm, provide your license and registration, and say nothing more. The moment the officer hands you a ticket or a warning, the legal basis for that stop is over. At that point, ask directly, "Am I free to go or am I being detained?" If you're free, leave. If you're being detained, he needs a new legal basis to hold you. Make him articulate it. Loophole number 2, holding you for a K-9 unit. The Supreme Court case Rodriguez versus United States addressed this precisely. Officers cannot extend a traffic stop beyond the time it reasonably takes to complete the purpose of that stop, issuing a ticket, running your license, just to wait for a drug-sniffing dog to arrive. If the stop is over and the officer wants to hold you longer, he must have independent reasonable suspicion or probable cause to justify that extension. If you feel like you're being held longer than necessary, keep asking. Officer, am I free to go? Keep asking calmly. Keep it on the recording. Every second they hold you without legal justification is potential grounds for a challenge in court. Loophole number 3, consent. And this is the big one. Consent cures everything. The moment you say yes, the moment you say go ahead, the moment you step aside or hand over your keys or open a door, you have waived your Fourth Amendment rights entirely. It doesn't matter what the officer told you. It doesn't matter that you felt pressured. It doesn't matter that you didn't fully understand what you were agreeing to. Once consent is given, the search is legal. Full stop. The phrase to memorize, write it on the back of your hand if you have to, is this: I do not consent to a search. Say it clearly, say it calmly, say it once, then stop talking. That's it. That's your shield. 5 words. Now, what about furtive movements? Because this is another tool officers use to justify searches, and it's one that targets the very natural human response of nervousness. A furtive movement is any sudden, suspicious movement, reaching quickly, ducking down, grabbing something, shifting unexpectedly in your seat. Courts in Texas, California, and across the country have generally ruled that a furtive movement alone does not establish probable cause. In Gonzalez versus State, a Texas court ruled explicitly that a furtive gesture without additional corroborating factors was not sufficient to justify a search. But here's the danger. Officers stack observations. They combine the claimed smell with your supposed nervousness with an alleged furtive movement. And now they have a pile of facts that they argue together amount to probable cause. Each one is weak individually. Together they argue they're sufficient. So here's what you do if an officer accuses you of making a furtive movement. Officer, I didn't reach for anything. I am in compliance, but I do not consent to a search. And nervousness itself? In United States versus Selkalo, courts have noted that nervousness is an unreliable indicator of criminal behavior. Nearly every innocent person who gets pulled over is nervous. It's a human response to authority and flashing lights. Courts know this. And if you tell the officer plainly, Officer, I'm trying to remain calm, but I do not consent to any search, you have put your refusal on the record without providing anything they can use against you. Now, what if the officer ignores all of it? What if he searches your car anyway? This is the moment that trips people up the most, because every instinct in your body wants to fight back, to grab his arm, to raise your voice, to demand he stop. Don't. Under no circumstances do you physically interfere, because the moment you do, you have handed him a new charge: resisting, obstruction, assault on a public servant, and now your ability to challenge the illegal search in court is buried under new legitimate charges. Here's what you do instead. Step 1. Stay completely calm. Keep your hands visible. Do not make any quick movements. If you have a phone available and you can safely record, record everything, video and audio. It is legal in all 50 states to record police during the performance of their duties. Step 2. Provide only what is legally required: license, registration, proof of insurance. That's the complete list, nothing else. If the officer asks where you're coming from, where you're going, who you know, what you've been doing, Officer, I'm exercising my right to remain silent. Step 3. Never consent, even if the search is already happening. Continuing to say, I do not consent to this search matters. It matters for the court record. It matters for your attorney later. Even if the officer proceeds anyway, your stated refusal has legal weight. Step 4. The moment you receive a ticket or a warning, ask immediately, am I free to go or am I being detained? The purpose of the stop has ended. They need new justification to hold you. Now, what if it's not a traffic stop? What if you're at home and an officer comes to your front door, banging, insisting he can smell marijuana from your porch? Here's the truth that most people don't realize. You do not have to open your door. Not for a police officer, not for anyone. Unless that officer has a valid warrant signed by a judge authorizing entry into your specific home, he cannot come inside. Not based on smell, not based on a hunch, not based on anything. You can speak to him through the closed door. You should speak to him through the closed door. And the first thing you ask is simple. Officer, do you have a warrant? If the answer is no, and it usually is, that's the end of the conversation. You are under no obligation to open that door, answer questions, or explain anything about yourself or your home. If he claims to have a warrant, ask to see it. Have him slide it under the door or hold it to the window. Read it carefully. A warrant must specify the location to be searched and what officers are authorized to look for. If what he's looking for and where he's authorized to search don't match your home and your situation precisely, that warrant may be legally insufficient. And what about that classic line, "If you don't cooperate, this is going to get a lot worse for you"? That is a pressure tactic. It is not a law. It is not a legal threat with substance. You can respond clearly. I am invoking my Fourth Amendment rights. I will not open this door without a valid warrant. Finally, what if you're not in a car and not at home? You're just walking down the street and an officer approaches you and says he smells marijuana. That is what the law calls a consensual encounter. When a police officer walks up to you on the street with no legal basis to detain you, you have the right to simply keep walking. You can acknowledge him if you choose. You don't have to. You have no legal obligation to stop, to answer questions, or to engage. If he steps in front of you, if he physically tries to stop you, ask immediately, "Am I being detained or am I free to go?" If you are not being detained, you can walk away. If he says you're not being detained, but then asks why you won't talk to him, you don't owe him an explanation. Keep walking. But if that officer says the words, "You are being detained," now the rules shift. Now you are in a temporary legal hold, and he must have reasonable suspicion to justify it. At this point, invoke your rights clearly. I do not consent to a search. I am invoking my right to remain silent. I want an attorney present before any questioning. And then say nothing else. This is the hardest part, because silence feels awkward. Silence in the presence of authority feels wrong, like you're being rude or uncooperative. But silence is not suspicious. Silence is protected. Silence is your most powerful legal tool in that moment, and experienced defense attorneys like Theodore Whitman will tell you the same thing every single time. More people damage their own cases by talking than by anything the police find. The smell of marijuana has been used as a weapon against American drivers for decades. But weapons only work when the target doesn't know they're holding a shield. You now know the law. You know the questions to ask. You know the phrases to say. You know the traps to avoid. The next time those blue and red lights appear in your mirror, or the next time a cop knocks on your door, or steps into your path on the sidewalk, you will not panic. You will not hand over your rights. You will not be another case file in the system because you said the wrong thing at the wrong moment. You will stay calm. You will say the right words. And you will walk away with your rights intact. Now, here's something else you need to know. Cops using the smell of marijuana is just one of the tools in their playbook. They have others. They lie, legally, deliberately. And if you don't know the 10 lies police are trained to use during encounters, you are not fully protected. That video breaks down every single one. Watch it next.